This is session 2. Session 2 is about self-advocacy and litigation in employment matters. And we're going to first have a presentation. I guess I should say a little bit more than that. I think one of the problems that I run into a lot as chairman of the NFPA Employment Committee, of which Monique is a member, is that people are running into many different kinds of barriers. And so this seminar is going to try to teach you as job seekers and as people who work with job seekers, the tools that you can use to overcome those barriers. So our first presenter is going to be Monique Melton of the Colorado Center for the Blind and the Employment Committee. She's going to be talking about preventing barriers. So, got 10 minutes, Monique.
All right, thanks, and welcome to everyone. So I'm going to be talking about more so asking for accommodations and advocating for yourself during the hiring process and on the job, because those are definitely barriers that are faced by us as blind employees, or can be. So starting with self-advocacy, there are a few parts to self-advocacy. We heard that term a lot this morning. Knowing your rights is one of those, and that's definitely an important one. The other two are knowing yourself and being able to communicate your needs. And I'm going to start with knowing your rights, because I want to give you some good news that you all do have rights. That's why you're here. You feel like you have rights probably, or you're curious to know if you have rights, and you do. You have rights to reasonable accommodations in the hiring process, including the application process, and on the job. And so know that, get in contact with Valerie or Scott. Dick has a lot of great information, has been doing this a lot longer than I have been. John Perret also. All of these are great resources. Talking to your voc rehab counselor about rights that you may have, or some of these disability rights organizations in different states can all be great resources to get familiar with your rights and what's available to you. But with rights comes responsibilities. And so Scott said it earlier, we have some work to do on our end as well. So knowing yourself, being self-aware, knowing what your blindness and other disabilities limit you from doing, and knowing how you have gotten around those limitations in the past, maybe from school experiences, maybe just different things that you've figured out going through life. But knowing yourself, knowing what your limitations are, and how to overcome those, and being able to communicate your needs. So that is, being able to talk, like John was talking about, being polite when you talk, being professional when you talk to an employer, to the hiring manager, to the HR team about the needs that you're trying to get met. Looking at my notes here. Okay. So I mentioned reasonable accommodation, and that's in the law for a specific reason. It's because you're not going to be able to get any accommodation you want, but you're going to have to work with your employer, hiring manager, HR team to figure out what is reasonable for you and also for the company, to allow you to complete the tasks you need to complete. Before you start talking about reasonable accommodations, though, you have to disclose your disability. And I know that's a touchy subject for people. you don't know how to do that, don't know when is the best time to do that, don't feel comfortable doing that in certain situations, but you definitely have to. And I don't want to talk about the merits of when you should do it, but I do, want to point out some ways of doing it. And it's a personal choice when you do it. So that's why I'm not going to get into the merits of when to do it or how you should do it. You could do it on your resume. You could do it in a cover letter. You know, working with Voc Rehab, there are job developers, and so they may have disclosed it in talking to companies about you as an employee. You could write a letter. You could disclose it over the phone when you're called for an interview, or for maybe to come in and do some testing for a job or something like that. But you do have to disclose your disability, because employers can't accommodate what they don't know about, right? So um, disclose your disability. So, okay, going back to this reasonable accommodation. So during the hiring process, that might look like um, providing a reader for some testing that you have to do for a job, or um, figuring out ways to get access to screen readers so you can complete those tests. Different things like that. Not changes to the application, but changes in how you get the application. That's another thing that may be done. As far as accommodations on the job, so you're gonna, talk to your employer, HR team, manager about accommodations on the job, because you may lose your vision, may have lost your vision during the course of your employment. And so the same kind of process applies, disclosing your disability, talking to the employer about needing these changes that will allow you to complete your job tasks. And so um, having that conversation. So some accommodations that you might get on the job include access to reader services, providing screen readers or braille displays, changes in lighting conditions, maybe working from home, or changes in schedule to allow for, maybe paratransit or public transit doesn't run at a certain time, and you can still get work done by maybe coming in a little later or leaving a little early if you have to. Getting materials in alternative formats, audio, or maybe emailing things beforehand. Another accommodation that I've seen is for employers to pay for gas mileage for drivers. Also, labeling equipment might be something that you and your employer work out. And like I said, it's a conversation between you and the employer. And so I started off with good news that you have rights, right? But the news that maybe you don't want to hear is that you're not always going to be able to get the exact accommodation that you want. You should definitely share what works best for you and how your needs have been met in the past. If this is not the first time that you're being accommodated for your disability, but something that you also have to be willing to accept is compromise and flexibility. So Scott mentioned the undue hardship on the company. And so it might be an undue hardship for you to have all your materials in Braille, but you may be able to access those materials, in audio or from email. I'll let Scott share his information. I don't don't think he would mind me giving it out, but I'll let him do that. Um, but being willing to compromise with the employer to figure out what's going to be the best situation for you and for them to be able to allow you to do your job tasks and do them effectively and efficiently, and also so it doesn't cause that undue hardship on the employer. And when you go into these situations, make sure that you have the qualifications to perform the essential functions of the job, because that's what you'll be asking for accommodations for, is the essential functions of the job. So definitely taking a look at those, making sure that you are qualified to do those. You have the knowledge, skills, and abilities to perform those essential functions. And then you can take a look at reasonable accommodations. And again, that might be talking to folks in the NFB, talking to not only the legal and advocacy department of the NFB, but we have all these divisions. You could talk to people who work in human services, you could talk to lawyers, you could talk to merchants, you could talk to government employees, writers, science and engineer, all these different divisions that we have that you can tap into a wealth of knowledge and experience to give you ideas or help you get ideas of possible accommodations. So I hope, yep.
Oops, I'm sorry. Go ahead, please finish.
Oh, I was just going to say, hopefully that was helpful. And Dick, definitely, I was going to say, feel free to jump in and, add anything that I may have missed.
No, you're just fine. That was terrific. Now we're going to kind of have kind of a tag team with, sorry about using professional wrestling terms, but between Valerie will have time to talk about what to do when there is a barrier, and I believe that will be followed by Scott. So Valerie and Scott, please proceed.
Great. I think I'll start by talking about the EEOC complaint process, Scott, if that's okay. So hi, everyone. You might have heard me announce in the previous session that NFB is working on a self-advocacy toolkit for employment matters. When it's released, it will live on NFB's website, available through the legal webpage, alongside NFB's self-advocacy in higher education and self-advocacy in high-stakes testing toolkits. All will be dynamic toolkits, updated as needed and intended to be resources for you. We always welcome your feedback on these toolkits. So this presentation is a general outline of what will be included, particularly as it relates to the EEOC's complaint process. I'm going to add that Scott Labar is much more the expert on the EEOC than I am. So Scott, please jump in at any point to clarify or further define the EEOC complaint process. And I'm going to apologize upfront for some of this information being very dry. Please don't tune out. These are your protections and they are important. So the EEOC, or Equal Employment Opportunity Commission, is the federal agency responsible for enforcing non-discrimination employment law across all aspects of employment. Hiring, firing, pay, job assignments, promotions, layoff, training, fringe benefits, and any other term or condition of employment. EEOC's oversight includes enforcing Title I of the ADA and Section 501 of the Rehabilitation Act. Most employers with 15 or more employees fall under the EEOC's oversight. Per the EEOC, disability discrimination occurs when an employer treats a qualified individual with a disability, who is an employee or applicant, unfavorably because they have a disability. This can be in the form of accommodation denial, harassment, retaliation, or other disparate action. Monique talked about some best practices for requesting workplace accommodations. While it's not required that you formally request accommodations in writing, doing so creates a written record, which is helpful should you ever need to file a complaint against your employer for a refusal to accommodate. So federal law requires an employer to provide reasonable accommodations to an employee or job applicant with a disability, unless doing so would be unduly burdensome or expensive for the employer. We've talked about that in a couple of different ways already. And I think Monique's suggestions are great. I will urge you to advocate for the accommodations you need. It can be easy for an employer to say that something's too expensive when in fact it's not. So I raise this point to urge you to not stop pursuing accommodation just because an employer tells you it'll cost too much. As Monique alluded to, reasonable accommodation is a change in the work environment or in the way things are usually done. Reasonable accommodations must be provided to qualified employees regardless of whether they work part-time or full-time or are considered probationary. As you know, sometimes employers deny accommodation requests or delay providing them for so long that it's an effective denial. Your rights to accommodations are protected, and part of these protections include the option of filing a disability discrimination charge with the EEOC. Unlike other parts of the ADA and Rehab Act, individuals who wish to file a federal lawsuit regarding employment discrimination must first exhaust the EEOC's complaint process. If you've been discriminated against by an employer and choose to file a complaint, you have to do so within a specified time frame. This is generally 180 days from the date the discrimination occurred, unless you live in a state that provides for a 300-day statute of limitations. If you're a federal employee, you have a much smaller window of time, only 45 days. Unless you're a federal employee, and I'll highlight that process later, to file an employment discrimination charge, you could file online, by mail, or in person at an EEOC office. You could also file through your state's Fair Employment Practices Agency. These state agencies coordinate with the EEOC, and if you file a charge with either EEOC or your state agency, the charge will automatically be cross-filed with the other agency, so there's no need for you to file with both. Though EEOC does not accept discrimination charges by telephone, you can always call the EEOC to discuss your experience with a representative, which can be helpful as you think through your next steps. When you file your charge, you want to be sure that your narrative is clear, concise, and objective. If you have supporting documentation, such as emails from a supervisor, you can include those with your filing. You don't have to have an attorney to file a discrimination charge with the EEOC, but working with an attorney can help you craft a better complaint. If you're searching for an attorney, you can contact the NFB's legal program. We may not be able to assist directly. We have a robust but limited legal program. The NFB receives more requests for assistance with employment matters than for any other category of discrimination. 120 requests for help with employment discrimination matters in 2019. But the NFB is part of a broader Disability Rights Bar Association, and we can connect members with disability rights attorneys in their state who, generally for a fee, might be able to provide some support. After you filed your charge, you can check on the status via the EEOC's web portal. And at any point, you can amend to your complaint if, for example, you locate additional supporting documents or if another act of discrimination occurs. After you file, the EEOC may offer mediation. The EEOC's mediation is free and conducted by a trained and experienced mediator, so says its website. If the parties reach consensus during mediation, an agreement can be entered into, and this written, signed agreement is enforceable in court just like any other contract. If an agreement is not reached during mediation, your charge will proceed to the investigation phase. Mediation can be useful because it can be a faster way to resolve a complaint compared to waiting for EEOC to complete an investigation. The EEOC's website says that while it takes less than 3 months on average to resolve a charge through mediation, it can take 10 months or longer for a charge to be investigated. And please keep in mind that investigations can take much longer than 10 months. And I'm not sure what the average length of time has been during this COVID-19 crisis. If you are not interested in mediation and your goal is to file a federal lawsuit regarding the discrimination you experienced, you can request that EEOC send you a right to sue letter, which gives you permission to file in federal court. You can make this request 180 days after filing your charge of discrimination. And upon issuing your right to sue letter, EEOC will close your investigation. or the investigation into your complaint. The EEOC may issue you a right to sue letter as the result of its investigation. This can be frustrating if you don't want to take your matter to federal court. Note that after you receive a right to sue letter, you have only 90 days to file in court. Sometimes after investigating a complaint, the EEOC will litigate the matter. We'll hear from a member shortly who's had this experience. The EEOC litigates a very small percentage of the complaints filed. Per EEOC's website, when deciding whether to file a lawsuit, the EEOC considers factors such as the strength of the evidence, the issues in the case, and the wider impact the lawsuit could have on the EEOC's efforts to combat workplace discrimination. I mentioned earlier that if you are a federal employee, you are protected from discrimination and retaliation by law, but your process for filing an employment discrimination complaint differs in a few important ways. First of all, your window for filing a discrimination charge is only 45 days after the act of discrimination occurs. And second, you must file with your employer's EEO office. After you file, you will likely be offered the option of participating either in EEO counseling or in an alternative dispute resolution program such as mediation. If counseling or mediation are not successful, then you can file a formal discrimination complaint via your agency's EEO office. After you receive notice from your EEO counselor about how to file, you have only 15 days to submit your complaint. After you file a formal complaint, your agency's EEO office will investigate your complaint and then issue a notice giving you two choices: either request a hearing before an EEOC administrative judge or ask the agency to issue a decision as to whether the discrimination occurred. And I found this fascinating. If you proceed with the hearing, after reviewing the evidence, the judge will make a decision and order relief if discrimination is found. Then the agency will issue a final order in which it determines whether it agrees with the judge. At this point, if you disagree with the final order, you can appeal to the EEOC or you can file a federal lawsuit. And if you decide to bypass a hearing and request that your agency issue a final decision and then disagree with that decision, you also can appeal to the EEOC or then file suit in federal court. So in a nutshell, that's the EEOC complaint process. I strongly encourage you to familiarize yourself with these steps and your protections under federal law so that if the time comes that you do need to file a complaint, you'll be ready. And now we'll move on to the much more exciting interview with Scott LaBarre and Alina Sorling. Thanks.
Thank you, Valerie, and you laid it all out incredibly well. The only other thing I would add here is keep in mind that some of your states, well, most of your states, as a matter of fact, have their own agencies, human rights agencies, civil rights agencies, they call it all kinds of things, fair employment practices agencies, whatever. And you might want to look at what your rights are under state law and whether or not the state agency acts faster than the EEOC. Valerie, the statistics you cited from EEOC's website as to how timely they are, I don't know what they're smoking, but my practical experience is it takes a lot longer than that. So now I want to introduce to everybody, and hopefully she's up and unmuted, I want to have you meet Alina Sorling. She is a member of the National Federation of the Blind from Redding, California. And we filed a case on her behalf over the last several years. And it really is illustrative of how this process can work. And so, Alina, are you there? Technology. Beth, do you see her still?
She's there but muted. Alina, can you unmute yourself?
If you're on the phone, Alina, just dialing it. Go ahead.
Me?
Yes.
Hi.
Hey, there you are, Alina. Good morning. I know it's a little bit earlier there in California, but can you tell us a little bit about yourself and how you found yourself working for Mercy Hospital in Redding, California?
Yeah. My name's Alina, and I got hired at Mercy 2004, and I worked there for almost 11 years as a dietary food tech. So I cooked and I ran the register in the hospital.
Okay. And you were part of a union, is that correct?
Yes.
And by the time, and then, so you had been working there 10 or 11 years. So your seniority at that point was pretty good, right?
Uh-huh.
So what happened at that point? At the time you started with Mercy Hospital, you were sighted, right? You had a normal vision.
Yes.
And then what happened?
In 2014, I was having issues with my asthma and I was working a lot. And on my birthday, I was actually off that day and I got called in. But anyways, I lost my eyesight. I was put into an induced coma to relax my lungs. And about a month later, they woke me up. And when they woke me up, I was completely paralyzed and legally blind. And once they decided to take the tube out of my throat and I was able to talk, you know, my number one was right there, my job, and I was told not to worry and that they would find something for me to do.
Okay, and as I understand it, the paralysis it went away, but your blindness obviously didn't. And so what did you do at that point to try and get your job back?
Well, I had to go to rehabilitation, physical rehabilitation, and got, you know, like you said, what do you call that word? Not paralyzed anymore, and rehabilitate myself to walk again. And also, I was part of the Department of Rehabilitation, and so I started in with after I was able to leave the facility for a month of the outpatient rehabilitation. Then they were working with me with technology like JAWS and programs and mobility training. And we used to actually go to the hospital and train around there as well.
So you actually did mobility training in the environment where you were hoping to work?
Yep,
Okay.
I did.
So then tell us a little bit about what happened when you said to the hospital, hey, listen, I've recovered. I've gone off and gotten some blindness training. I've learned about the tools that I need to use. I want my job back. What happened then?
Okay, well, it was explained to me that my medical leave was exhausted and that I was no longer a dietary, you know, even supplemental, that I lost my position and that I would need to reapply for jobs. And that was kind of confusing for me. And I had to go to a meeting with the HR department. And that's when I began taking my notes with my Victor Streamer. And so in that time that I needed to do an interactive, and they explained what I would have to do, find a job, apply for it. So that went on for a while, and I applied for several different jobs. And even one of the jobs that I was already doing, someone else with less seniority than me got the job. So it was kind of hard time. But during all my different interviews, I was taking notes and able to record conversations. And I did the whole interactive process. And also, Department of was willing to have someone come in to evaluate the workspace, and they wouldn't allow it, an outsider coming in. And I gave them the full list of accommodations that I thought that I would need to do the jobs, and it still wasn't good enough.
So let me just point out here that, and I can't remember if you mentioned this or not, Alina, but when you came out of your coma and you started to get the rehab, the hospital first promised you that your job would still be there.
Yeah, the
You-
president and the president of the hospital and one of the sisters was on my bedside during that time and told me no worries, that they promised that no matter what, they'd find something for me to do. Because I had a family to raise, 4 children, and, and so they were strongly telling me that not worry, that I would be able to work again. And so,
everybody in this last hour plus, we were talking about the importance of knowing your rights. You can see that Alina learned what her rights were, that she was entitled to an interactive process to discuss the accommodations. She was prepared. She prepared a big, long list of accommodations that would allow her to do her job, such as a talking cash register. She offered to them that the Department of Rehabilitation would come in and do a job evaluation and suggest accommodations. She told you that she was learning how to travel with a cane and actually learning to do so on the hospital premises. In other words, she was doing all the things she possibly could to be prepared, to show the hospital that she was a problem solver, to tell them that she was eager to come back to work. And look, the other thing she did is she kept copious notes. I can tell you, as the attorney who handled this case, along with my good friend Tim Elder there in California, she took all kinds of notes, as she calls it, on her streamer. I mean, we had hundreds of files with detailed notes about what happened on this day, who she called, what she learned. It was awesome. It was awesome. She was very prepared. So, Alina, you did all of that, and did the hospital give you your job back?
nope.
What did they
No.
say?
Well, I feel what happened, they didn't finish the, what do you call it, the interactive process, because I paid very good attention on what steps I was told to do and to complete the interactive process. And I decided to get a hold of someone. I didn't go through the NFB.
And by the way, Alina, you're fading in and out a little bit, so I don't know if you can maybe move to a place where your signal's a bit better.
Okay, yeah.
This virtual stuff is wonderful, but it does have its drawbacks.
Can you hear me better? I took the voiceover off.
Oh,
Can you hear
I
me?
hear you just fine. So let's proceed this way. But so then, Alina had done everything she possibly could. She had contacted the NFB. She talked to Valerie Yingling. She talked to Tim. Ultimately, I got involved. But then what happened next, Alina? Did you file a complaint with the EEOC?
Yes, I did.
Okay.
So,
and what did the EEOC do with it?
they found that there was discrimination in cause. So then Tim Elder
And before
was
they
able to
even
help
did
me.
that, Alina, before they even did that, did they come to Reading and do a thorough investigation?
Yes. I also had heard that the private investigator was legally blind, and she went in through the cafeteria where I worked, and demonstrated areas that I would be working as well. So I thought that was pretty neat, and that both of my lawyers were blind, and so it gave me a lot of hope, that if I can have a blind, private investigator, and also 2 blind lawyers on my side, and the EEOC, I felt like I had a lot of support, especially with the NFB being there as well. So it kept me strong in having some type of hope that this wouldn't ever happen to anyone else, if anything.
And that's right, folks. The investigator from the EEOC happened to be a blind person. And of course, Tim and I are blind. And so it meant a lot, I think, to Alina that she was being supported by a blind professional. So ultimately, the EEOC did find probable cause. This is another part of their process, that discrimination occurred. Now, when the EEOC does that, a number of things can happen. We tried mediation at that time. It didn't work. So then the EEOC had to make the decision of whether or not to bring this as a case where they file a lawsuit in federal court and enforce the federal law. They did decide to do that, and that is incredibly rare. And the reason that they decided that in this case was because the facts were so strong and the client was also very strong. Now, the hospital said that Alina could not be rehired because her employment would pose a direct threat to her health and safety because, get a load of this, folks, they said blind people couldn't work with hot items, pots and pans. Blind people couldn't use knives safely, and that the kitchen environment was far too dangerous. So look, if you were thinking about preparing yourself a hot lunch or making dinner tonight, forget about it, because I don't want you handling any hot items. I don't want you cutting yourself with any knives because you're dangerous, or at least that's what this hospital thought. So the EEOC filed a lawsuit as a matter of right, as an individual, to protect her rights. Alina had a right to intervene formally in the case and become what's called a plaintiff intervener. We did that. We joined the case, and we started to proceed through discovery. And we learned that they did not really have any defense, that the only information they were using to make their decision that Alina was a direct threat was, in fact, their stereotypes and misunderstandings about blindness. They had no objective evidence that Alina was going to be truly a direct threat on the job. And one of the things I remember, Alina, was when they took your deposition and they were asking you whether you really could do these job tasks, you were able to tell them that you were already hired at another place in food service. Can you tell us a little bit about the job you found?
I was going to say, with working with Department of Rehabilitation and the Employment Opportunity Center as well, I was able to job shadow, I guess you'd say. I worked at the Mission, but prior to that, I went to the Lighthouse for the Blind, and what is that place? The camp. And
Hills, right?
Yep, Enchanted Hills. And I went up there and I did a program for just cooking. And I also shadowed the Mission here in Reading. And I even went to a dog treating place, you know, and shadowed jobs around. And then with that Employment Opportunity Center, we, you know, got resumes together and I applied for, you know, more jobs. And I got hired on at the local grocery store in my neighborhood in the bakery.
And yeah, you were doing bakery stuff and preparing food, and you were, by gosh, you were using knives, as I understand it.
Yep,
Well,
yep.
And so at her deposition, she was able to talk about all of this and say, look, I'm able to do this as a blind person. So what happened next? Well, we entered into settlement talks again, and we did settle the case. Except with the EEOC, we had the ability to file something called a consent decree, which is an order of the court, and all of it is public. But not only did Alina receive a financial compensation for what she had to go through, but they were ordered to change their policies and practices, to take training, to give training to all of their employees about the rights of disability, of those with disabilities. In particular, management had to take a bunch of training about accommodations and what direct threat really is. The management official who made the decision to fire Alina had to go through training, immersion training of blindness, and learn about the skills blind people have. And so in addition to all of the wonderful injunctive relief that we got, Alina won a cash settlement of $570,000, which covered her lost wages, emotional distress, and reimbursed the Federation for its legal fees. This was a 100% victory. Even though we didn't go all the way to trial, they didn't want to go to trial because they would have lost. And it was a terrific victory. And all of the elements of this case show how being prepared, being a great client can help you get a a solid result. So, Alina, what did it mean to you to have the support of the Federation through all of this?
Everything. I feel I couldn't have done it alone. And I met the right people, that led me to more right people. And the support was awesome. And that's all I got to say is I'd like to thank the National Federation of the Blind and Scott and Tim Elder, Valerie, and there's so many, local chapter meeting people I've met, Julie in Washington and Deborah Worsman. There's so many to list that Carla that's been there to help me through, and I didn't do it exactly alone. I had support, and if it wasn't for the NFB as well, I don't know where I would be.
And thank you very much, Alina. And it really, you were one of my favorite clients to work with because you were so dedicated, so prepared, and also so committed to making sure that this doesn't happen to other people. And that's why it was so important that this settlement was very public, very open, and everybody knew that this particular employer did the wrong thing, but they, I'll give them credit. They were ultimately willing to make a serious commitment to changing, and we salute them for that. But it's unfortunate that it took basically 5 years. This case started in 2014, and we just settled it last September of 2019. So thank you so much, Alina. Hang in there. Maybe somebody will have a question for you. Dick, I'll kick it back over to you for our Q&A.
Thank you.
Scott, I have, please, if you want to ask questions, raise your hands. But Scott and Valerie, I would like you, if you could just take a minute or two to kind of summarize the steps that you think people should take once they start to believe that they're being discriminated against in terms of employment or not getting the dialogue about reasonable accommodations that they do. Because one of the things that Alina made really, really clear is the importance of good preparation. So if people think they're in trouble, can you give a quick summary of what kind of steps you'd like them to take to make it easy for them to win these cases?
Well, I want them to do what Alina did. She educated herself about what her rights were. She learned what services were available, like the Department of Rehabilitation there in California going into the job site. She was persistent with the employer, and she made notes on everything. Very detailed notes saying at 8:30 on Friday the 13th or whatever, this and that happened. And then, when she realized that she was not able to solve this on her own, she called the local federation. She called our national office. She was very detailed in what was going on. And she step by step, she did what I think somebody should do.
Very nice. Thank you. Thank you so much. And I hope that all of you will take this to heart, because one of the things that helps us as an NFB is if you do your homework. It makes it easy for us to work with you. It makes it easy to do that, because as Scott pointed out and as Alina pointed out, sometimes these people don't know what they're doing, the people on the other side. And when it becomes very obvious that they did not engage in a dialogue with you about reasonable accommodations, they did not follow the steps that you're supposed to follow, the odds of them losing are quite a bit more significant. There's one thing I learned with working through Scott and the other NFB lawyers over the years is that, if they don't follow the rules, they stand a really good chance of losing.
And I got to say, I've had the pleasure of working with Dick on a number of cases. He's served as an excellent expert witness.
So, Beth, I'm going to let you recognize the participants.
Thank you.
I did have one question, Scott, that I can start out with. How can we combat systemic discrimination against blind applicants? They reject you or screen you out when they learn that you are a blind applicant before they see your real ability. So,
Well,
anyway.
the short answer really, and especially in that area, has to be a campaign of education, of changing the narrative from the beginning. There are other things I think we need to do legislatively and policy-wise, but we really don't have time to go into that. But the key here is education, because especially in the area of denial of a job right from the get-go, right at the application stage, that can get difficult, because how do you really know what the motivating factors were when they made the decision if you don't have a smoking gun? It gets to be very difficult, but there are a lot of things we need to do, and the main thing is educating people about the abilities of the blind, and that's a responsibility we all have.
Other questions?
Yes. The individual's last 4 digits of their telephone number are 5527. Your hand is up. The individual with the last 4 digits. There you are. Welcome.
Hello?
You're on.
Oh, you're on.
Hi, I'm Yvonne. I just had a quick question. I'm currently seeking my PhD in social work at an online university. And as a disabled person, I need a few accommodations, some that I provide myself. And there seems to be a problem with that. I'm being told that there's no law that they are to provide me any accommodations. So I'm trying to figure out the best way to self-advocate without having to go through legal ramifications or anything like that. Because I simply want to succeed in school and go on with my life.
Well, they do have a duty to accommodate you, and I think the best way to handle this is go to our website, look under our legal program for the the advocacy toolkit on education. There are lots of great resources there, right, Valerie?
Absolutely.
Okay. Next question.
Jillian Milton, your hand is up. Jillian Milton.
Jillian.
Okay. Hi, can you hear me?
You're coming
Yes.
through loud and clear. Yep.
Okay, cool. So before I ask my question, I just would like to announce that I am a proud member of the 2020 scholarship finalist class.
Okay.
Thank you. And my actual question, hold on. Yeah, so my actual question is, have there been any advocacy efforts about students connecting with interactive boards through screen sharing apps at the higher ed level?
That's an excellent question for our National Association of Blind Students. I don't know, but I want to say also, we told our scholarship winners to let people know that they're scholarship winners. So you did a great job, Jillian.
Thank you.
Okay, next question.
Amber C. Amber C., your hand is up. Amber, do you have a question? And could you unmute, please?
As she's doing that, I just got to say, Beth, you do such a great job. You sound like you should be on NPR or something.
I appreciate that. Amber, I believe we have you on
Yes,
the line.
can you hear me?
Amber, yes, please go ahead.
Yes, my name is Amber Shooping. I'm here in Chicago, and I am looking to work with the homeless shelter system to fight discrimination against blind and disabled individuals in placing them in homeless shelters. I believe this is a very crucial systematic failure to place people as, without placing them in homeless shelters, they end up on the streets and they're very vulnerable on the streets.
And your question is?
Yes, I wanted to know what steps can I take to further this cause, and which legislation applies, ADA or FHA, as these are nonprofit organizations and not public housing options?
Well, probably more the ADA in terms of a nonprofit offering services to the public, but it would depend a little bit in the nature of their programs and what they actually do. But in terms of how to get systemic change, work with your local affiliate of the National Federation of the Blind, see if there's legislation that you can bring or an advocacy educational campaign that could be brought. Those are the things I would recommend.
Leah Stone.
Thank you. Next question.
Oh, excuse me. Leah Stone. Leah Stone, if you would please unmute. Your hand is up. Leah Stone.
Leah?
Hi, I am Leah. I'm from New Jersey, and I have a question about disclosure and accommodation. So I recently received a contingent offer as a contact tracer, and I did not disclose during the application. In fact, I removed all references to disability in my application, and I was hired without an interview. So I am waiting for the final offer before I disclose and request accommodations because I don't trust the employer. Is this am I doing things in the correct order in waiting for a final offer?
Yes.
Cool.
That's the simple answer. There are, the question of whether to disclose or not. You're not obligated to disclose at the pre-employment stage, but sometimes there's reasons to disclose. But you're developing a very interesting case, Leah, and we want to hear about it because I hope they hire you. But now that once they hire you and you request accommodations, we'll see what happens. But you've done it right.
At this stick, Leo, would you please email me at ddavis@blindinc.org for the employment committee. We're interested in this topic of accessibility of contact tracer systems. Next question.
Juan Ortiz. Juan Ortiz, if you would please unmute. You have a question?
Yes. One resource that I use a lot with my customer is Jan. I believe you're familiar with it. Job Accommodation Network, because he have a lot of good information there for employers and for the customers about accommodation at the ADA. But this is, as a counselor, one of the questions that I will get many times, which I hope you have an answer. I never got an answer, so hopefully you got it. I'll send you a check in the mail. So I have customers that it's hard to notice if they have a disability. If they are legally blind, visually impaired, and they ask me when I go for the job interview, should I be, when they offer me, because I know they have to do it when they offer the job, should I disclose my disability to them when I already have Zoom tests, I already have a portable CCTV, I got everything that I can do for the job? Should I disclose? Would that be an issue with liability in the future? So what is your answer?
Dick, do you want to go ahead or you want me to go ahead?
Sorry, I missed the end of that. I was looking at the group chat. Please answer.
Okay, so basically, a person with disability is not under any obligation to disclose. So if they really do have all the tools and all of that, they do not have to disclose. Now, once the job offer is final and accepted, you do, in effect, if you're going to request accommodations or ask for a modification of any sort, then yes, you need to disclose, but not till that point.
That is correct. I think the law says, Scott, that if they want to give you, they can give you a tentative job offer and say we hire you conditional on us being able to come up with reasonable accommodations that will help you do the job. But I'm not a lawyer. That's just what I have heard.
Right. Well, that is essentially right. And this topic, actually, of to disclose or not to disclose, that is the question. this could be a whole seminar. And so we can't deal with all the contingencies here, but basically, one, if they have all the tools and they're ready to go and they really don't need anything from the employer, they have absolutely no duty to disclose until they're hired.
This is Monique. Can I just add one thing?
Please.
Well, of course.
So while you brought up, they have their own CCTV and all that, I would say that, that Scott and Dick are right. They don't need to disclose, but if it's gonna become an issue of them wanting to use their own equipment in the office, then I would think they would need to disclose at that point to bring in their own equipment.
Right, but that doesn't have to happen until they're actually hired.
Right.
Particular instance.
Exactly.
Let me throw something in. You're right. It's too long to discuss, but there may be, keep in mind on the disclosure thing, if the employer is an affirmative action employer with a federal contract or the federal government, it might be to your advantage to disclose. So please make the judgment based on if disclosing will help you. If you know it'll help you, it may be a good idea. If you don't know if it will help you, then you'll have to judge that.
Yeah, it's an interesting issue, and as I say, this could really be a whole seminar.
Scott and Valerie, do you want to take a couple more questions?
Well, I know some of us are getting ready for the board meeting. I don't know if now is a good time to end this session. What do you think, Scott?
One more question.
Okay.
One more. Okay.
Jessica Dawn Lamond. Jessica Dawn Lamond, do you have a question? If you could please unmute yourself. Thank you.
Hi. Can you guys hear me?
Yes.
Awesome. So, I'll try to be quick. I kind of had two questions, but I'll ask for the first one. When taking notes, Alina mentioned that she would record interviews on her Victor Reader. And I guess my question is, I know that there are a lot of legal things surrounding recording, and I'm wondering if you disclosed to your interviewer that they were being recorded, and if you think that had a negative effect on your interview.
I don't know if Alina's still up or not, but she did, generally speaking, disclose that she was recording and ask. And even though that, in this particular case, even though she was doing that, it really didn't change their conduct, is what I noticed. I will say this, the issue of recording, whether it's on the phone or in person, there are all kinds of different laws in different states, so know what your laws are. In some states, you have no duty to disclose that you're recording at all, as long as you are a party to the conversation. In other words, if I'm in an office talking with somebody and I want to record and I'm one of the parties involved, I don't have a duty to disclose. That's the law in some states. In some states, you have a duty to disclose. The same is true for the telephone, that sometimes as long as you are a party on the phone call, you have no duty to disclose that you're recording the call. In some states, you do have a duty. So you got to check that out. That's part of being prepared.
Dick, it can have a chilling effect on an interview. Please keep that in mind.
Okay. It can, but sometimes it doesn't, surprisingly.
Yeah, so it's crazy. Yeah, so these are things in which we can't give completely brilliant answers, but just kind of keep in mind, you'll have to feel your way. If I were recording an interview, I might record it and say, okay, I like to do this for my personal reference, later on. But I want to go into that, any further. Thank you all for being part of this. Thank you, Scott. Thank you, Valerie. Thank you. Alina.
Yep.
Yes, and thank you, definitely Monique, for all of your hard work. Please go to the website and download the tools, and Valerie is readily accessible, as is Scott, he runs, I think you're still the president of the National Association of Blind Attorneys, or the blind attorneys, or whatever they call them. So please come to his meeting, and thank you so much for coming to the seminar. It's terrific.